And if we don't quite have enough people, let me know, but I assume we do given the number of participants. Pleasure to be with everyone. I'm excited for today's meeting. We're going to get a lot done. We have a number of recommendations that have come out of the various work groups on which each of you serve. You all have each been hard at work, and this is fun because we get to see the fruits of all your efforts today. Before I go into some administrative matters, I wanted to check in with Justice Earls to see if you had any words of welcome as we start this full task force meeting today.
Yes, thank you so much, Attorney General Stein. And I just want to emphasize how clearly important the work is that we're doing, and also to say, don't take it for granted for a minute, all the time and effort that each of you has put into this. So we recognize it's been taken a lot of time and good consideration and input and honest discussions that have happened so far, and I just really appreciate that.
Absolutely. And the reason why this is fun is we're starting to see the fruits of all that hard work. Yes. Our first matter is approving the minutes of our October 9th meeting, which you each should have received. Does anyone have any comments or anyone like to make a motion?
So moved, sir, Mr. Chair.
Thank you, Mayor. Second?
Second.
All in favor?
Aye.
Aye. Any opposed? Thank you. Minutes are approved. The next item has to do with editing this document that is under construction. There is some draft language, introductory language, and setting the scene, which the staff has put together. And of course, Justice Earls and I will be reviewing next week. But if anyone would like to be a member of the editing team, we invite you to do so and welcome your participation. There was an email about this a couple weeks ago. So if you are interested, let any of the leads know, Jasmine, Natalia, John Paul, or Ellen, and we will make sure you get added and your editing pen considered. So thank you for that. We, in our final report, are going to list all of the members of the task force, and we would like to include pictures of your handsome faces. We all get to see you on Zoom, and so we want to get headshots. So if you haven't sent in your headshot yet, please send it to Ellen by the end of today, if at all possible. The schedule in terms of what is down the road, we have another task force meeting next Friday, Friday the 13th. Take no premonition from it. And then one on Wednesday, November 18th. And at that point, we hope to be able to have a draft report in everyone's hands by Friday, November 20th for consideration over the end of the month so that we can move forward at the beginning of December. For today's meeting, we have an amendment process that I would like to describe. And Ellen, I don't know if you want to bring some graphic up to the screen or not, but while she's doing that, we're going to have each work group make their presentation. And then if you want to amend it in some way, go to the chat feature, click at the bottom in the chat and type in what you want to achieve with your amendment. And we will discuss the amendment so that everybody understands what the purpose of it is. And then we will actually move that to the bottom of the list and go through the other proposals and consider them, so that while that's at the bottom of the list, staff is working on actually inputting the amended language into the recommendation. And then when we get to the bottom of the list and bring up that proposed amendment, we will vote on it, and it will be a majority vote. Are you in favor of the amendment or not? If people prefer the original language over the amended language, they should vote no for the amendment language, because then the original language will come back up for consideration if the amendment fails, and we will vote on the original. If people like the amendment language, obviously vote for the amendment, and if a majority passes, then the amendment will be adopted, and we will go from there. Anyone have any questions on that process and how it will work today? Jasmine, anything you wanted to add on that?
Just that we anticipated voting at the end of all of the working group presentations, not at the end of each individual working group on the amended language. So just to give us a little more time to make the drafts.
Very good. Okay, hearing no questions on that process, there are two recommendations that we as co-chairs would like you all to consider. And the first, I will hand off to Justice Earls. And this, I believe, is just for a preview and not a vote. Is that right, Justice Earls?
That's right. I'm not presenting anything to vote on right now. So I want to talk about two things, and they're interrelated. One is more time sensitive than the other. The two things are, what will the future work of this task force look like post December? So post what I'm calling our December report, what do we envision we will be doing through the next 2 years of the existence of this task force? And then separately, but interrelated, is the fact that we have for some time been talking about that we believe, and this is evidence-based, based on experience in other states, that this work there needs to be a more permanent entity that carries on the work of implementing these recommendations, monitoring their impact, looking at the racial data at various points within the criminal justice system, and continuing to work to ensure that we are getting closer to achieving racial equity. So what would that look like? And we think that the December report should include a recommendation for a permanent entity, even though it may not be needed, or it may not sort of come into operation until the work of this task force has completed. And when I talk about what that permanent structure might look like, you'll see that it might take some time to put it into place. So let me talk first about the future work of the task force, even though I feel like that we don't have to necessarily decide now. We can continue to think about that, and we can post the December report, we can have discussion on how our work should continue. But just to give you an initial starting point to think about. So we think that going forward, so post December of this year, that the task force would only meet quarterly, something like the first Friday in March, June, September, and December. But that there would be committees that would meet monthly, and those committees could meet more frequently if they needed to, but there would be an expectation that you would be on a committee and that would meet monthly, but the full task force would only meet quarterly. What would the task force be doing? We would be using the recommendations in the December report as a blueprint for our work going forward. We would be working to implement those proposals. In some instances, there might be further study, there might be additional recommendations that we want to make, but it's really an implementation of the strategies, and then monitoring what the impact of those are. So then how would the committees be structured? We're thinking, and this is where we definitely want your feedback based on your experience so far, that rather than the work groups by subject area that we have right now, that it makes sense in an implementation strategizing role that we be organized into committees that are the following. So a committee dealing with administrative rules. All the recommendations that are proposed to be implemented as administrative rule changes would be the responsibility of that committee. Then a legislative committee, a committee that would work on the recommendations that are to be implemented through legislation. Then the local policy change. So a lot of the recommendations.
Your audio cut
Pause
out.
volume.
Justice Earl.
We're not hearing you, Justice. Justice Earl, we're still not hearing you.
Okay.
So I have a question. I wasn't sure if I was frozen or Justice Earls was frozen.
I lost Justice Earls after local policy changes.
That's what happened. Okay. So Justice Earls, I think you're back now, but we heard the committee about administrative, legislative, and policy, but not beyond that.
I'm so sorry. I think, can you hear me now?
Yes.
Okay. I do think it's my internet and I apologize. Please wave at me if you can't hear me again. But local policy change was about as far as I got. So the three committees I talked about so far: administrative rule, legislation, local policy change, and then the fourth would be funding, outreach, and education. So as the title suggests, you'd be working on figuring out strategies for programmatic support funding for for the recommendations, what kind of public education.
Justice Earls, we lost you again. Well, until she comes back, she's previewing this. And look, we understand that we have asked immense commitments on each one of you, and you all have met our requests by giving unbelievable numbers of hours to this exercise. And I just wish all of the people of North Carolina could really appreciate how hard all of you have been working. But we also realize that is in no way sustainable. And so we want to, when we get past the recommendation side to the implementation side, be a little bit more reasonable in terms of what our expectations of you are, and ask that you sign up for one of these committees and then help us do the implementation, and we meet fully on a quarterly basis. And then what we'll do is send this around for everybody to review before we actually vote on it. Justice Earls, you're back.
Yes, sorry. Thank you for letting me know. Hopefully reconnecting solved the problem. So the other piece of what I want to talk about is, what does this, I think you've wrapped up this notion of how we might move forward. So the other piece is the permanent commission. And this is, again, where we will circulate this and you'll have time to see it in writing and to offer whatever suggestions, changes. But the concept is that this would be a commission on racial equity, that a permanent commission established by legislation. It would be a little bit smaller than what we have now, but the membership would be set out. There would be representations from the stakeholder groups that are currently represented here. And the governor would appoint this commission, and it would have a staff. The commission would prepare annual reports. It would do racial impact reports as a decision, and get that into the hands of policymakers and decision makers. The commission could make recommendations. They would do monitoring and evaluation, and they would make sure that we are getting the kind of racial data on the criminal justice system that we, through this work, have clearly seen is so important. So I know I've run through that really fast, but I think get a sense of what we're suggesting. And so that is the thing that needs more urgent attention, because we want to put some, it may not need to be quite as detailed as exactly what size or exactly who the stakeholders will be, but we want to have something in the December report that says, we recommend that this ultimately become a permanent commission that carries on the work of furthering racial equity. So, so look for that early next week, and give us your feedback on what a permanent commission should look like. And
very much, Justice Earls. The second co-chair proposal that we put before you is a Sentinel Review Committee and a Sentinel Event Review. And I don't know if there's anything to put up on the screen, either Ellen or Jasmine, but this recommendation has to do with improving the way we respond as law enforcement to big events, either a police-involved shooting or a police-involved excessive use of force that may result in serious bodily injury or death. And the idea is to separate this from any internal affairs review done by local law enforcement, where they are doing a review in order to determine if the person merits some kind of sanction internally, the officer who was involved. This is separate from any kind of civil or criminal action that may result based on the person's action. This is purely to review what happened so that law enforcement broadly can learn any lessons. There may not have even been anyone at fault. Maybe there was nothing done wrong according to what happened, but is there something that we can take away from it to reduce the likelihood of such an event happening in the future? And this kind of review is common in deaths that occur in hospital systems and airplane crashes. And the whole idea is to try to reduce the likelihood of such an occurrence in the future. And as you can see, here's what the recommendation reads. And it would be born out of the Training and Standards Commissions, both sheriff and criminal justice, that are part of the Department of Justice. Anything else to show on this chart, or any more text, or is that it?
We're happy to bring up the full text of the recommendation if that would be helpful for members of the task force. I believe Greg has it pulled up.
All right, in that event, I'll leave it to the members of the task force as to whether they would like to see any more of the text. This was sent around to you for a straw poll, and at this point, we'll open it up for discussion. So does anyone have any ideas, questions, comments, suggestions?
Good morning.
Anderson?
I like the Sentinel event review concept. And I think the connection between hospital and airplane reviews is really helpful. I was thinking that the membership of that committee would benefit from some outside participation. So the proposal that 4 of the 7 seats be determined by the 2 sheriffs training organization. I was thinking that at least that one of those positions be dedicated to either a member of the North Carolina Black Lawyers Association or the North Carolina Advocates for Justice, a respected legal professional who might be able to contribute in a way that's from a perspective that's outside of the DOJ, and a concern that the one legal observer would be appointed by the SBI representative suggests that legal observer would probably be either an existing prosecutor or a long-term prosecutor, and that for the purposes of greater representation, more diverse representation, that we designate a legal observer with some greater independence.
Greg, pull up the document and put the, bring it to the composition of the task force of the review committee. So there are two groups. There's the committee itself, which is intended to be people with expertise in law enforcement. And then there is, scroll down 1 second more, and then we'll come back up. Then there is the people, they're supposed to do outreach in the local community. Now go back up, Greg, to the membership of the actual task force. So scroll down a little bit. My screen's not there. Perfect. So one member of the legal profession, SBI. Well, maybe what we can do is have the Attorney General appoint the member of the legal profession rather than the director of the SBI. What do you think of that? Or what's your kind of proposal here, Henderson?
Actually, I'm surprised to see that my language actually appears here. It's like magic.
Yeah, so I was gonna say, Henderson, it looks like you made your edits in the cloud document, so that means the version everybody has your edits.
So I'm grateful that that actually worked. So that's my proposal. I do think having the AG make the appointment. I think having it made from a slate that of recommendations by other legal organizations. So I propose 3 legal organizations: the Black Lawyers Association, the Advocates for Justice, and the Bar Association. I can imagine there might be a different array of organizations, but the goal is that appointment be made from an independent set of legal professionals.
How about we put that lawyer language to a member of the legal profession below? I think it's important that there be 4, so there's 2 from the sheriffs and 2 from the police, because I just think from the 2 commissions there should be 2 members each. And so what if we put the AG picks from member from the legal profession provided from a slate from these organizations, as you say?
Mr. Attorney General, this is Secretary Hooks, and I fully support the change. Moving to the AG appointment is more appropriate than the director of the Bureau making an appointment.
All right, thank you, Director Hooks. Henderson, does that work for you?
Yeah, I see that as a friendly amendment.
Okay, well then why don't we, I don't think we need to put that in the comment section since it's in the document itself. I think our team can make those changes and we will bring this as amended back to the full task force at the end of this meeting. Before we leave the Sentinel event review, I want to offer it up for further discussion for the full task force. So Greg, why don't you take this document down, then we can look at each other's faces. Anybody else have any other reactions?
General Stein?
Yes, Chief Letney, please.
Good morning, everyone. Just a couple of questions. I'm not overly familiar with this concept other than our discussions, which I think have been very robust. But for example, in the medical profession, when they do Sentinel event reviews, are there members that do that are outside the medical roles itself? In the NTSB reviews of airplane crashes, are there people outside the expertise of the aviation field? And then while I support some legal representation, I wouldn't want to limit it to any particular organization or representation. That should be open to the Attorney General to pick. And then I also want to be clear that this is really not a legal review. This is an operational review to determine best practices, what could be done better. So I think that's the underlying goal of a Sentinel event review, if I understand it correctly.
Thank you, Chief Letney. Ellen or Jasmine, do you all know what the composition is in the healthcare and aviation fields?
They are generally professionals in those fields. What we've seen in the few places where Sentinel event reviews have been conducted in this context, they have been a little bit broader given the context for which these incidents take place, because they are so there are interactions between community and professionals as opposed to just professionals.
My recollection is the Sentinel event review process grew out of Atul Gawande's checklist book, which exploded like a bomb across all professions, and that it would take some adaptation to each situation that is being reviewed. And so when we're talking about this kind of review that ultimately involves community and community impact, I think it's without question that Sentinel event review would have that broader participation. I think that's completely consistent with the originating concept that Gawande set out and that has been used in professions across the spectrum ever since.
Any other thoughts or questions, folks?
Thanks, Michael.
Good morning, everybody. This is Kerwin Pittman. I don't have the document directly in front of me, but when we was discussing the Sentinel event review, one of the things that kind of struck me most or stuck out to me was, was the use of excessive force. So in extreme instances of real extreme excessive force, I don't know if that was added to the document. I believe that was one of my concerns that I had put previously, but I haven't looked at it per se. But so do we want to put when extreme use of excessive force is in there for a Sentinel event review, or just when something deadly happened, or if it's just a shooting? And I say that to come to mind the incident in particular that happened in Raleigh with a guy by the name of Kyron Hinton, in which it was multiple agencies. And I believe a Sentinel event review would be gravely needed for instances like that to try to prevent different instances like that from happening. So maybe we should look at excessive use of force to be added into the language if it's not already put in there.
Kerwin, it is there. The definition of Sentinel events in the recommendation is use of force by a law enforcement officer against a member of the public that results in serious bodily injury or death, or sexual assault or rape by a law enforcement officer against a member of the public. And I believe there was a suggestion that domestic violence be included there as well, but I don't know that we got it into the language. So we may have to test out our amendment process on that point as well. I think that was Angelica who had made that point. But it does leave open that the committee will consider annually the addition of any other negative outcomes for consideration for the Sentinel review process, including excessive use of force. But it does say serious bodily injury right now.
We have a sense of the volume of those incidents currently, and I would imagine both commissions would need staff. And are we able to gear up for this kind of thing? Because I imagine it's a lot of work for each individual incident, and the volume is something I think we need to be mindful of.
As I understand it, correct me, Jasmine, if I'm wrong, is not every incident necessarily triggers this review. It actually has to be agreed upon by the commission or by the review team to do it. And I think it's because to your point, Chief Letney, we don't know yet what the demand will be, what the resource needs will be. And so really we want to launch this and have them start doing the work. Ideally, it would become, if it proves to be successful, as we hope that it does, it would become institutionalized and be deployed in every incident as it is with NTSB on plane crashes. But at this point, we're just trying to get it launched.
Thank you.
About 1 more minute for further comments. Remember, we can use the comment and the Q&A feature if you have further questions that come up later on.
Okay, so we'll shelve this one and then bring it back up on the back end once we've got the amendment finalized. And now we'll transition to Working Group 3, who will kick us off. Representative Murray, the floor is yours.
Okay, thank you. Good morning, everyone. I will go through what Working Group 3 has recommended so far, and then we have 4 major topics today that we have put out for the straw poll. And we also took into account your comments, and we have split some up, and appreciate the feedback on that. As our last task force, and Working Group 3 is charged to make meaningful systemic changes in court procedures to achieve racial equity. So that is our parameter. We've already unanimously endorsed robust racial equity training for all court officials, for getting AOC to include racial data in the annual tally report, that we have approved recommendations for sunset provisions on local ordinance crimes that criminalize poverty, behavior in public places. We are encouraging law enforcement to issue citations in lieu of arrest whenever possible for misdemeanors. We have encouraged law enforcement prosecutors to work together for diversion programs and expand that access where appropriate. We made recommendations on juvenile justice reform to raise the minimum age to 12. And any school-based offenses with an SRO must also be signed off by a school social worker or administrator. So that's where we have come so far with our recommendations. They have all passed the task force. Today, you'll see in our agenda, we're going to go through 4 major topics. And we will start with the bail and pretrial services. If we can put that up. And I think we will split out some of this for the vote based on your comments, because there are almost 13 separate ideas or recommendations. But overall, what we're looking at in our bail system is revising what we do, because we know disproportionately people of color are arrested and held on cash bail. Excuse me. So what we're saying is that we need to follow what the statute says, that there is a preference that people be released with a promise to appear. Going further on that and knowing the numbers, the racial disparities, we're recommending that we eliminate financial conditions, which is cash bail, for any misdemeanors, unless a judge finds that there exists a danger to another person or an intimidation of a witness. So that's a big change. Other states are moving in that direction. We listened to a presentation by the New Jersey Deputy Attorney General, how they have made their reform that's been very successful. Jasmine McGee talked about the work group here with the Attorney General's work group on bail reform. And Jesse Smith also presented on the bail reform and the consent lawsuit in Alamance County. So we, as a working group, agreed to this and passed this on for the task force recommendation. Another provision, which I think we'll vote on separately, in North Carolina, there is no requirement of a first appearance for anyone charged with a misdemeanor. So some of these, if we eliminate cash bail for misdemeanors, this may not come into effect. But if it doesn't, we are saying that anyone that is being held in jail should have an appearance before a judge within 48 hours or the next day of district court, so a judge will review the bail conditions that were imposed typically by a magistrate. In some counties, we have people sitting on a misdemeanor larceny charge for 30 days in jail because they can't make a $500 or $1,000 bond. This is trying to rectify that. If a person is charged with a felony, they need a first appearance. So if they're being charged with a misdemeanor, we're saying they should come before the court official within 48 hours to review whatever financial condition it is. Next, And this is also what was passed in New Jersey. Our work group talked about it, a preventative detention hearing within 5 days of secured bond being set. And it's also similar to what we do in juvenile court. Kids in juvenile court aren't entitled to any bond, but there's by statute, they have to come back and be reviewed and see if anything has changed about their conditions of detention. So it would be the same thing, a preventative detention hearing within 5 days of a secure bond being set. We're recommending new responses for people that failure to appear in court on their charge, that if they would come to court and go to the clerk or make some other arrangements, that there wouldn't be an automatic strike of the order for arrest on the failure to appear on the first time. We have a lot of people that transportation issues, family emergencies, medical emergencies, they miss their first court date. And if they miss their first court date, even if it's a trespass, it's an automatic failure to appear order for arrest. So this is trying to be a little more forgiving, a little more cognizant of the realities of people's lives. We did this in Durham and it was very successful. Anywhere from 50 to 100 people, we would strike their failure to appear, reset their court date, and they would be back. So we're trying to propose this for a statewide plan. The next proposal is an independent pretrial services. Our working group heard from 3 pretrial services in Orange County and Durham and also in Mecklenburg, how they have set it up. Pretrial services that will work with people if they are released for pretrial. They will notify them of their court date. They will make sure they get to court. They may provide other drug testing, transportation, but they have been very successful, and that we would be encouraging other communities and counties to implement pretrial services. Similar to the failure to appear, oftentimes if someone fails to appear for a traffic violation, it can result in a suspension of their driver's license on the first failure to appear, that we would eliminate any suspension of a driver's license for a fail to appear on the first occasion. And then finally, improve a statewide data collection. And this will be, to monitor our recommendations, see what the racial disparities are. That is pretty much our list of the pretrial bail. I don't know if we want to take any questions or keep going through whatever the chairs or Karen.
Yes, wanted to check in with anyone if they've had any reaction questions before we move on. Hearing none, again, please feel free to use the chat. Representative Maury, do you want to go ahead or did you want to take this for a vote?
Whatever the chair's pleasure is, we could go ahead and then come up to the votes.
Why don't we go ahead? Why don't we go to the next, please?
Okay, thank you. Okay, we're gonna now shift to our next category, and this is about juvenile life without parole. Our work group heard from some experts in this. We have noted that 29 states have eliminated juvenile life without parole, including Washington, D.C. This is to get North Carolina more in compliance with what the United States Supreme Court has ordered in 2 cases, Montgomery and Miller. We currently have over 1,000 people in our prison that have committed crimes when they were juveniles, under the age of 18. Some of these were sentenced to juvenile life without parole. And I think when we looked at the racial data on this, it was astounding. 91.5% of any person currently in prison on a juvenile life without parole is a person of color. A tremendous disproportionate racial disparity in juvenile life without parole. Looking at this and having looked at the other states that have made statutory recommendations, we are encouraging the task force to replace our juvenile life without parole sentences to allow juveniles that are now adults serving in prison be eligible for a parole review hearing. This does not mean they would get out. It means they are simply eligible to go before the parole board to find out about their rehabilitation, if they would be able to be released safely in our communities. And this would be after a 25 years if they were convicted of a first-degree murder, and parole eligible after 15 years if they had been convicted of other offenses, not murder, and sentenced to more than 15 years. Along with, and that's a legislative recommendation, but administratively, the recommendation is to establish a juvenile review board within the governor's clemency office. The governor's clemency office is, I think, a staff of 1. So it would be to enhance his clemency office, review sentences imposed on juveniles, and make recommendations to the governor concerning clemency and commutation of any sentences when appropriate. Once again, it's not an automatic clemency. It is simply reviewing cases after a substantial period of time to see if candidates would be eligible to be released. Those are our juvenile life without parole recommendations.
Again, did you want to just go ahead? Yes.
Are there, okay, we'll go ahead and entertain any questions on or discussion after this.
Exactly.
Okay.
So why don't you do the discussion on each proposal? We can vote on them all at the end.
Okay.
Yeah, I was going to make that suggestion as well. I just want to intervene just to say I think this is an extraordinary piece of work that Working Group 3 has done. I've been able to monitor it and was invited to participate or to at least eavesdrop on some of their deliberations. And I think the value of this recommendation is both with juvenile life without parole, but it cuts across to something that to issues that Working Group 4 has been spending a good deal of time about, and that's extreme sentencing. We were impacted by a 14-year-old who was given life without parole, and sort of hearing how that sentence and that cruelty was only undone after a process that sort of mimics what is being proposed here, where the prosecutor could take a second look at that sentence, did so, and that life without parole sentence was reduced to 20 years. So I'm sure that I know that we're going to get into some of the similar principles in the extreme sentencing proposals that will be coming out of Working Group 4. But I just want to take this opportunity to commend Working Group 3, I think, for the extraordinary record that they put together on this proposal, and just express my appreciation for that good and hard work.
Thank you, Henderson.
Other comments, reactions, things that you like about it? Any suggestion for an amendment?
Yes, this is Kerwin Pittman. Oh, excuse me, go ahead.
Yeah, this is, I don't have computer access today. This is Jim Woodall. Can I be heard?
Yes, you can.
Yeah, I just wanted to let everybody know I was on Working Group 3. However, I opposed this recommendation on juvenile life without parole because I feel like we've made promises to victims' families. I understand there are significant racial disparities, but I've made promises to victims' families that we would fight for these life without parole sentences in these cases, and I plan to keep that promise. So I just wanted everyone to know that I was opposed to this.
All right. Thank you. Thank you, Jim.
This is Kerwin Pittman. I just have one quick question. So for individuals who do come up for parole, is there any additional provision in there if they are denied that additionally they will come up after X amount of years again, or is that the end all be all to their coming up for parole?
Corinne, thank you. They would be eligible. They would, if they are rejected after a period of time, usually 2 years, they would be able to come back before the parole review. In fact, we had a presentation by one young offender in Tennessee who had a substantial sentence. I think he served 30 years. He came up for parole. He was denied. He completed some more of the requirements of educational and programs in the prison. He came back before the review and he was released.
As Henderson again, I would like to respond to Jim's comments and to suggest that this is an issue that is ripe for further discussion within the profession about the nature of promises that are made to victim families and or other stakeholders, and how those promises can or should impact the review of sentences after some period of time. And in this regard, I would particularly refer folks to the work of the American Legal Institute, the ALI, the producers of the Model Penal Code. And the basic theory that they put forward is that sentences of extreme length are sort of assume perfect knowledge at the time of the sentence. And that 20 years later, 15 years later, 25 years later, other facts about whether it's redemption, the crime, institutional adjustment, all of those things become relevant considerations. And that the system needs a greater provision for adopting or adapting that new information, that new reality to sentences that may have been passed 15, 20, 25, 30 years earlier. And I think that's an issue that the profession is going to have to do more wrestling with. And that's an issue that Working Group 4, I think, will be making recommendations on as well.
Jim, did you have another comment?
Yeah, if you can, if you hear me. Yeah, no, I respect that position, but I also remember, Henderson, in one of the early meetings, you mentioned on some fair sentencing cases that we had made promises to those people who had been convicted, and we needed to keep those promises. I just feel very strongly, because I've worked with hundreds of victims over the years and hundreds of victims' families, that we have made promises to them. One of the most heinous crimes that I've experienced, I've worked on in my 30 plus years as a prosecutor, was a juvenile who committed a horrible murder and had committed another murder. And I simply, again, say that I will stand by my promise to my victim's family, and I will fight as long as I'm a prosecutor and when I leave prosecution to keep that person in prison.
And not to get into a debate, but part of what the ALI is suggesting is that 20 years later, the person that you fought like hell to keep in prison, it may still be appropriate to take that position 20, 25 years later. The problem is not so much whether or not 25 years later it should be imposed, it's just whether our system of justice requires a provision for looking at the facts 20, 25, 30 years later to see if there are significant changes that should alter that outcome and would require or justify that explanation to victim families or other stakeholders.
Well, I just disagree. Families live with homicides. The families of victims, they live with those murders every day. They change their lives. They ruin their lives. And I believe that the promise that that person will stay in prison the rest of their life without the benefit of parole is a promise that should be kept.
If I can weigh in as a victim service agency that works tirelessly on behalf of victims, I just want us to be very cautious of having this one view of what victims want. In my experience, we have victims that all they want is for this person not to commit another crime, right? Another similar crime. Some victims want just for that perpetrator or defendant to admit that they did wrong, and that we have victims who want them to be able to rehabilitate. It's not always necessarily, and I understand with the loss of a life is a tremendous loss, but I also want to caution us to think that all victims want that, because there are a lot of victims that just want the perpetrator to admit blame, to be rehabilitated so they don't have to do it again. And so it's much more complex than that. And so I just want to make sure that when we talk about what victims want, that that we have, victims are not a monolith. There are victims that want different things. And so one of the things that I would suggest that if we are going to talk on the behalf of victims is that we actually ask like a larger pool of victims in terms of what their input would be on that. But more than anything, as someone who serves victims and survivors of crime, I think that oftentimes the criminal justice system isn't necessarily the only way that folks can get healing. And that is one of the things that we see time and time again. And we know a lot of victims where the perpetrator is in prison for the rest of their lives and they're no closer to healing than before. And again, I don't want to talk on behalf of all victims, but I do want to stress on the fact that not all victims feel that way.
Yeah. I've just got to say, I disagree with you when it comes to first degree murder, which is what we're talking about here. I think the great majority of victims do feel that way. I prosecuted somewhere around 60 homicides over the years. And in my first degree murder cases here in a very progressive district, the family of victims in homicide cases are virtually unanimous that they want to see the first degree murder spend the rest of their lives in jail. And so I disagree with you on that when it comes to first degree murder conviction.
I appreciate your feedback, and I would respectfully disagree again with this assumption that this is how all the victims feel. And it's okay for us to disagree.
All right, thank you. Thank you for that.
Look, the only thing I want to add, we have made this proposal because of the extreme racial disparity of 91% juveniles of color have gotten life without parole. And I think everything Jim said, and I respect, I was a prosecutor, I was a judge. I mean, it is heart-wrenching. There's no guarantee of parole. The very case he promised someone they will never get out, that very well may be true if they go to a parole review board and they are denied, and they will spend their life in prison. This is giving an opportunity to have a hearing after 25 years. So I think Jim dissented to the recommendation, which is noted and we respect. I think everyone else, Commissioner Smith, Senator Muhammad, and Tara Callahan, and I voted for it. So we will leave that and give that to the task force to vote on. But thank you.
Well, and I agree, but I have to say one other thing. I do think even when parole reviews come up, it is a re-victimization of these families. So I just think people have to realize that.
Thank you, Jim. I'm going to ask Representative Moore if you would go on to your next one, because we were getting close to needing to vote.
Okay.
Everyone for your comments. I appreciate it.
The next one, I believe, is a recommendation to end citizen-initiated charges. This recommendation is that if there are criminal charges, they should be initiated with law enforcement. That people should not be able to run down to a magistrate and say, my neighbor trashed my lawn, or a rock was thrown through my window and I want to take out a criminal charge for injury to personal property, something like that. I cannot tell you about the racial disparity in this, other than my own experience, 18 years sitting in Durham's district courtroom. We had a people's court, and it was every Friday, and it was citizen-initiated warrants. We tried to mediate these charges, and it was predominantly African Americans coming in to this courtroom. We were trying to mediate so people wouldn't have a criminal conviction on disputes. We were successful mediating, but I think this recommendation is saying, let's not have people initiate and have permanent criminal records on others. If it rises to a serious concern, get the involvement of law enforcement officers. So I think it's a very simple recommendation. We have looked, there's in the SharePoint, law student Bradley Anderton did a great piece on it. He looked at all 50 states. North Carolina is only one of 14 states that specifically allows for citizen-initiated criminal charges. So that is our recommendation. If there are any questions, or we can put it off for a vote.
Any questions, comments?
I actually just had a comment about this recommendation because it raised for me a slightly different issue that we haven't, that I don't think the work groups have wrestled with, and that is the problem, which I think arises in a very different set of cases than what this recommendation is actually getting at, but the situations where, and I think this arises in the African-American community, there's a sense that when African-Americans are the victim of the crime, that there is not the same level of, the criminal justice system doesn't address that crime. And so this kind of spurred for me thinking about recommendations that I know, or processes that exist in other states where the Attorney General has the legal authority to bring a prosecution if the local district attorney indicates they will not prosecute. And so I just wanted to flag that I think that's an issue worth considering in this process.
Thank you, Justice Earl.
I also have a comment. In Robeson County, a large portion of the cases we see in criminal court are private citizen initiated charges. During COVID, however, private citizens were precluded from seeing the magistrate to initiate these charges. So they were forced to seek relief by other means, such as through 50Bs that had to be denied because there was no legal basis. So they were basically stuck for about a period of 6 months. Our sheriff's department, local police departments just did not have the resources available to assist these private citizens. And that's my concerns, that if we're to do away with them, how are these folks then going to get the relief they need through the criminal justice system? I think more resources need to be poured into these sheriff's departments or police departments. At least that's my experience here in Robeson County, because during this 6-month period, our sheriff, I mean, they were just completely swamped and they couldn't assist these folks coming in every day, every hour with trespassing or assault charges or whatever the case may be. So that's my only concern. There needs to be access to justice.
Thank you, Judge Clark.
Can I add just a little, a different perspective to it from a law enforcement officer standpoint? That tool sometimes gives the opportunity for parties to calm down. And then there are many cases where people dial 911 and they want somebody charged. And then you give them the option of going down there and filing that charge themselves. Then they realize there's some work that they have to do. And then they find it not worth the effort. And so then that charge doesn't get filed. Where if we just put it on law enforcement, obviously if somebody calls 911 and they demand it, we're going to have to do it. And then we're increasing the contact between law enforcement and folks. And if we're already saying that there's this racial disparity in this event, then we're going to force law enforcement to take part in that without any other recourse. And sometimes we show up and we say, hey, you know, you're more than welcome to go down to the magistrate if you feel that strongly about it. And the majority of my experience has been the majority of the time, once we put it back on them, they tend to not go down there. So I think removing that option just really puts law enforcement in a bad predicament.
Very much for your comments. Other comments?
This is Secretary Hooks. Could I see the proposal one more time before us? I wanted to know if there's any differentiation between assaultive complaints versus, you know, trespass and some of these other things that people may go to the magistrate for.
Greg, can you put that up? Back up.
Or maybe Representative Judge Morey, if she could just kind of let us know if there was a differentiation. It's fine if it's more.
Thank you, Secretary Hook. No, the recommendation didn't make a differentiation. That it was, if there was a incident that would become a criminal charge, it would take law enforcement to take out that criminal charge. Otherwise, citizens would not be able to go down to a magistrate to have criminal charges. They could do civil suits, they could do whatever, but thanks for your question. And that could be an amendment.
All right then.
Okay, and I will go through the last recommendation is on decriminalization. And it is recommending to enact legislation to reclassify all the Class 3 misdemeanors that have no impact on public safety or emergency management. Non-criminal civil infractions would be what a Class 3 misdemeanor would become. And the examples are public urination, sleeping in a public place, taxi fraud, open containers, consuming in public places, begging. We had a presentation by Jesse Smith. We have about 11,000 of these charges in 2019. 80% are dismissed by prosecutors. So we're saying, let's look at these charges, take them out of a Class 3 misdemeanor. They could become infractions. And also collaborate with the General Statutes Commission to do more of a criminal review, a review of our criminal code, and make further recommendations and move traffic offenses from criminal to administrative code, depending on, as long as public safety is not at risk with some of the traffic offenses. But that is to have the General Statutes Commission do a review of that. That would be our recommendation on decriminalization. And I think that covers it.
I did have a question on this particular item. I know we talked before. I'm certainly sensitive to some of the reclassifications for some of those things that, again, as you said, don't affect public safety. I think urination, particularly in light of COVID and other diseases that can be spread through bodily fluids, is a tricky one, particularly for local municipalities to be able to enforce. And I think because of that and because of the unknowns for public health, which ties to public safety, I would ask that there be some reconsideration on that one. To make that only civil penalty will make it practically impossible to enforce without any real consequences. And it could have dire impact on people's health, which is a part of public safety.
And are you proposing that as an amendment, Mayor Copeland?
I would. I'm not on this particular committee or work group, but I was asking if they would consider some amendments to that.
Okay.
Mayor, I think I would respond that, you know, if there is shown this charge could impact public safety, that would not be part of the reclassification. So that language is in there. So as we take it further to implementation, you know, I think your comments about, you know, a particular charge, if we show a link to public safety, then there may not be a reclassification.
Okay.
So I know when we talked about it before, I think the committee had agreed by consensus that it would move to this stage. Now, what stage are you proposing that you have to make that verification in order to do that. I mean, there are a series of diseases that are passed through bodily fluid exchanges. So what evidence are you saying, or at what stage would that be discussed?
Well, probably at the bill drafting and the legislation that would be recommended, and the language in there that these particular class 3 misdemeanors do not impact public safety. So I'm sure there would be robust discussion in a House or Senate committee on the dangers of public urination.
Representative Maury, this is Josh. Why don't we just delete public urination from this included but not limited to list? And then we can let the scientists tell us whether public urination impacts public safety or not. And it can be added in later if it's not. And if it is, we'll keep it off. But by putting it in the including here, we're expressly saying it's not impacting public safety, and we don't know that.
Okay.
Thank you.
Mayor, would that work? Just an amendment to just delete public urination, and we'll let the scientists tell us later?
Yes, sir. I think that fits my concern.
Representative Maury, I did want to also let the group know that that included list was based on some data that the data team helped the working group get around those class 3 misdemeanors that have the largest racial disparities that did not impact public safety, allegedly. So that's where that list came from.
Okay. Thank you.
I noted on the amendment.
All right, it's
that's it.
Okay, we're getting close to time to vote, but before I turn that over for voting, wanted to check in with, are there any other comments? Okay, then. Well, then
I would, and I'm sorry, I'd just like to thank Work Group 3. We have a marvelous working group, and Natalia with the governor's office has been our fearless leader and drafter. And so thank you, and Michael and Karen.
all right, then, you are quite welcome. So let's move to Attorney General Stein. We want to go for voting?
Yes,
So,
please. We'll go ahead and vote, and we'll take them in turn of discussion. We will be tabling the last one till the end of this session today because of the amendment. And I can't remember if the other ones had amendments or not, but Ellen, if you can bring forward the poll.
Certainly. This is for the pretrial and bail set of recommendations.
All right, everyone's have the poll up on their screen. Go ahead and vote. Alan, should we keep voting, or are you going to tell us the results?
Sorry, I was muted. Not everyone has voted yet. About 17 folks have voted. So I'm just giving a few more seconds.
Okay, great.
And pulling down the decrim. All right, we still are at 17 folks who have voted. If anyone is still currently taking this survey, go ahead and raise your hand and I will give you a little more time. If not, I will end. Okay, great. I'm gonna end the polling and share the results.
And for those who can't see the results, who are watching on the internet, they all passed, either almost all of them unanimously. The other one was overwhelming. Thank you. And that was, by the way, that was for the bail reform issues.
And next, I will launch the poll on the juvenile life without parole and citizen-initiated charges. We will wait on the decrim until the end of the meeting, if that works for you, Attorney General Stein.
Yes.
We are at 15 votes, so I'm waiting on 2 more folks to go ahead and submit their answers. There we go. All right. I will end the poll and share the results.
And these, for those at home, was the juvenile life without parole having eligibility at 25 years, not release, but eligibility passed 94-6. The review board and the clemency office, similar 94-6. And give the potential for abuse. The citizens initiated criminal charges elimination was the closest election we've had yet, 59-41, it passed. And then we're going to hold off on the decriminalization issue of misdemeanors that do not affect public safety for the amendment till the end. So I think Representative Maury, Work Group 3 is off the hook. Great work. Appreciate y'all's efforts. And we will transition to Work Group 4. Henderson.
Good morning. Thank you. I'm still stuck by the Attorney General's characterization of this as fun, and what that says about the Attorney General, what it says about us. It's scary. But I do appreciate Justice Earle's description of monthly meetings and quarterly meetings as opposed to the weekly meetings that Working Group 4 has had. So I'll take this opportunity to thank Mercedes, our staff lead, Judge Locklear Clark, Judge Alan Thornburg, Mary Pollard, Mike Hawkins, Commissioner Hawkins. And it's just amazing that in addition to weekly meetings, people have found fun in reading and bringing to the attention of fellow task members, working group members, articles, research, commentary, statistics from the Sentencing Project, from some of our research assets like Brandon Garrett at Duke, Frank Baumgartner, and so that the research link, the SharePoint, has a rich set of resources that track some of the work of Working Group 4. And coming after Representative Maury's description and presentation of recommendations, I think our load today will be relatively light in terms of recommendations. I would contrast that with what we've got planned for you ahead. And I'll spend a minute or two, maybe a little bit more than a minute or two, describing what we've got ahead of us. And I will then pause for other members to make comment about that. But looking at the work of the working group, in some ways it was fun. Collateral consequences, learning about stakeholders and associations that have been working in this area for years. The State Reentry Commission offered rich insights into what will end up being circulated in our straw poll soon. And that fits a pattern with the other issues that we anticipate coming to the task force. We took on a review of prison discipline and the racial disparities that are evident in some of the disciplinary processes, some of the disciplinary sentencing at the institution. And then we had just, I think, tremendous participation, feedback and criticism, challenging, from the Department of Public Safety. Commissioner Ishii shared with us some of the work of the 5-year strategic plan, some of which was extraordinarily promising in terms of bringing DPS into alliance with some national and international standards, particularly with respect to restrictive housing and solitary confinement. I think there's more ground to be closed between those, and I think part of our recommendations will be, will encourage that gap be closed. So I think we should be looking forward to those recommendations. But I think other parts of the work that we've been doing includes some of the reentry provisions that are connected to restorative justice principles. And we had a shared experience with Working Group 3, where we heard from Danielle Surred and other folks who are working in this space. And Ms. Surred is a visionary in this area. And I think part of what she had to contribute was resonant with what Angelica had to say, that that we need to take a real careful look and listen to the breadth of views that harm parties and survivors have. And I'll note here that Working Group 4 has been impacted by several public comments, participation from the public who have listened in or saw some parts of our deliberations. We've gotten a couple of 3 letters from inside the prison walls. We've gotten outreach, letters, phone calls with harm parties and survivors of crime. And one of the things that were incredibly informative was the common ground expressed between survivors of crime, in this case, the wife of the homicide victim, and folks on the inside, talking about the failure of the system and the common failure in the system that both of these stakeholders identified was the system's inability to look for real signs of remorse or redemption, affording no opportunity for there to be any sort of effort, process for reconciliation or exchange between the offender and the harmed party. And we noted some of the efforts, some of the starts at particular facilities. And I think it was Craggy in Asheville that had a Bridges to Life program that was a start in that direction. So we were impressed that DPS was making some starts in these important directions. And I think with the recommendations that will come out of Working Group 4 will encourage and identify further efforts. I think a big part of what will be coming in the very near future, as in like a week or 10 days, are recommendations that get to extreme sentences and our response to that. And much of it will build on knowledge, studies, resources that are a decade or more in the formation. Much of it will build on the academic work of some of the research experts that have made their expertise and their learning available to the working group. Just this week, our working group had an extraordinary presentation by the Honorable Spencer Merriweather, District Attorney in Mecklenburg County, and Ken Rose, a longtime capital defense lawyer. The overlap between both of those professionals and on the role of prosecutorial discretion was extraordinary, and how they led to different outcomes in terms of whether or not habitual felon status should be continued, and the progress of the North Carolina death penalty statute and interpretation, and how, and we'll hear more of this, I think, in the template that gets distributed and in the straw poll that gets distributed. But being present for that conversation about the historic role that North Carolina death penalty statute has charted out about discretion. And for many, many years, until 2001, it foreclosed DAs from using discretion in terms of seeking the death penalty for first-degree murder or life sentence, and that we still live with the effects of that decision, a legislative decision not to allow prosecutorial discretion in this most important area. So I guess what I'm saying in this overview is Working Group 4 has taken on some very difficult and complicated issues, and we've had the benefit of many of the rich resources in North Carolina, in the universities and in the professions. Looking at the habitual felon statute, looking at the numbers, the racial disparities of people of color being sentenced to habitual felons, between 60% of that population being African American or people of color. Violent habitual felons, that number is 80% people of color. And to see that overlap between the juvenile life without parole that Representative Morey describes is really shocking. This is why there's a lack of confidence in our community about the operation of the criminal justice system. There seems to be a set of justice reserved for people of color versus that which is applied to white people. And the notion that this is not new, this draws roots to our difficult history of race relations going back to the period of enslavement. So what we've got, and I think what we've got to look forward to, are recommendations that attempt to undo, to redress some of these historic problems. One thing that's noteworthy, and one of the things that has come out in the SharePoint and other contributions, we haven't had the formal straw poll and discussion among members. But the notion that there's not been an execution in North Carolina for 14 years. Isn't this an appropriate time to formalize a moratorium against executions and engage the kind of study commission that could look at the racial disparate impact of wrongful convictions, wrongful sentences? Look at the list of exonerations. We had a presentation that 9 of the 10 exonerations from death row were people of color. Do I see a hook, Michael?
Oh, yes, sir.
Okay, well, recognizing that hook.
I appreciate you.
Recognizing that hook.
Yes,
I'm going to invite Mercedes and especially Mary to help us work through the recommendation that we are putting before the task force this morning. And this is something that we've had a fair bit of input on. from other task force members and other stakeholders, and we're pleased with where we are and pleased to present it to the task force. Mercedes?
Great, thank you. So our recommendations fall under 3 overarching ideas. And note that there is a typo on this one slide, and it should just read state reliance here, not municipal. But beginning with the first one, recommendation 1 is reducing court fines and fees. You guys have seen the language on this. It has not changed too much from when the feedback that was provided. Thank you so much for the feedback on the straw poll. These break down into quite specific recommendations. 1 being repealing the installment fee, 2, repealing the jail fees, 3, making it explicit in the statute that the $250 community service week fee can be waived. The 4th recommendation being that lab fees are only assessed for what is actually paid, not to exceed $600. That fee right now is currently a flat fee of $600. There's a recommendation on the table to reduce the supervision fee, also allow it for it to be waived, and then preclude the imposition of a supervision fee. And we're talking about supervision fees is for people that are on probation. Preclude the imposition of a supervision fee when the sole reason for extending probation is to comply with monetary obligations. The supervision fee right now is currently $40 a month. The 6th recommendation is reducing the general court of justice fee for infractions and driving offenses. Specifically, that fee currently is the same for infractions and driving offenses and all misdemeanors. 7th recommendation is, as part of structured sentencing, include a maximum fee for misdemeanors, including DWIs, that is based on a sliding scale. And then the last one is reducing a failure to pay, or a failure to appear fee from $200 to $100. And just for informational purposes, going back to the first recommendation, an installment fee, there's currently a $20 installment fee that is assessed on any individual that is not able to pay their court costs on the day of their conviction, and they're assessed. So ultimately, it's a payment plan fee that is assessed $20 per. So open now to discuss those, answer any questions, or we can put them to the floor for discussion.
I did have a couple of questions, and excuse my lack of knowledge in this area, but what are or did you all discuss the budgetary impacts if you change these fees as to how the different counties or local governments adjust to that, number 1? So will this require any type of supplemental funding? 2, your fee waivers for some of the things like jail fee or those things that you noted, are there any type of means testing done? So people who can't pay, or was this a blanket reduction of fees and waiver for everybody, regardless of whether you have the ability to pay or not?
Right. So there is not currently, just one of the first recommendations that the task force made, right, was the ability to pay assessment tool. So that is hopefully not going to be in effect going forward, but it is not necessarily being conducted today until that rule goes into effect regarding an ability to pay assessment. And depending on the fine and the fee, and there is a list, lots of them, depending on which fine and fee it is explicit in the statute whether it can be waived or not. When it comes to community service and I believe the supervision fee, it's not as explicit that it can be waived by a judge. And so just making sure that that is very clear to everybody that those fees can be waived is the purpose of that recommendation. With respect to your first question about the impact on the budget, we do have some numbers in the larger document that I can pull up that has the full text of the recommendation. And we we do have the numbers about how much money that would be kind of displacing or taking out of the system, noting that with respect to the installment fee, last year it was assessed over 162,000 times, which resulted in approximately just under $3 million going into the state general's fund. All fines and fees go to the state general fund. And so I think the working group, and the working group can speak for itself, obviously, thought that was not enough to put that burden on the individuals that are already having trouble paying, right? And there are also some numbers with respect to how much money is going with the jail fee. And there's also data that shows that a lot of these fines and fees go unpaid, such that they're not really ever collected in the first place. And so, but I'll let the members themselves speak to that as well.
Mercedes, this is Mike Hawkins. And also in response to that question, I'm chairman of the Board of Commissioners in Transylvania County, and I asked my staff to look up what do we get from these fees, and specifically I wanted to know about the jail fees, the $10 a day jail fees. And in Transylvania County last year, it was about $1,200, which is a tiny amount in the great scheme of things.
Thank you, Mike, for providing that context.
I should say one of the things that I discovered that sort of made you proud of North Carolina traditions and culture is that unlike Ferguson, these fees are not, there isn't a monetary incentive to agencies to arrest and detain and incarcerate so that they can get the fees. And so part of what we're trying to do here is make sure that these court costs and fees are not so disabling to people who are caught up in the court system that it presents yet another obstacle, yet another collateral consequence of their justice involvement that prevents them from fully reintegrating. And frankly, it's easier to do that here in North Carolina than it is in a lot of other states in other circumstances.
And that actually goes, Henderson, to like the second recommendation regarding eliminating state reliance on fines and fees. And the second recommendation has been modified since y'all last saw it, but it is ultimately to restore funding from the legislature for the DMV hearing program and eliminate the DMV hearing fee for non-impaired driving related offenses. So ultimately in January of 2018, that program became completely receipt funded. And at the same time, they're operating with about 7 hearing officers out of allotted slots for 22. So there are hearing fees that are opposed for DMV hearings that range from $40 to $450. And that program is ultimately completely receipt funded. And so the recommendation coming from the working group on this part, in order to again eliminate kind of government reliance on fees, is to restore funding for the DMV hearing program and eliminate the hearing fees. Then lastly, but there are several that fall under this specific recommendation, is developing a process to eliminate criminal justice debt. As we've already discussed in response to the mayor, there has already been a recommendation for an ability to pay assessment to be conducted. The following recommendations are a little bit in the weeds, but ultimately there is a recommendation to repeal the provisions that require the Administrative Office of the Courts to report to the General Assembly the name by name of judge who is waiving fees. There's currently a report requirement, and it is reported by judge. Repealing that provision, as there had been kind of talk, and the numbers have shown that there has been a drastic decrease in the number of fees that are waived after that reporting requirement went into place. The third recommendation is to clarify either by statute or a memorandum of understanding that the notice that the Administrative Office of the Courts is putting forth to different state agencies and stakeholders, if a fine or fee is waived, that notice is meeting the notice requirements that are required by certain statutes in the Constitution. Fourth recommendation is for judges to use a standard AOC form when considering waivers of fines and fees. And there is a form out there already that is been drafted and hopefully going to be rolled out. There's a lot of, that recommendation includes a lot of training to different judges and attorneys who will be using it, and also making that form accessible to pro se defendants, the clerk as well, and providing training to IDS and contract attorneys on how to use that form on getting the fee waivers. There is a recommendation 3.5 to establish an AOC form that would allow for the a failure to strike a failure to appear or comply for a traffic violation. There's currently not a form for that makes up a significant percentage of the failure to appears and failure to comply, and it would ultimately be an administrative burden that would kind of take that out of the courts, if they're, or not out of the courts, but out of more of a standard process. Excuse me. Sixth recommendation is allowing a first strike for a failure to appear to occur administratively. I think this is the one I was thinking of that would take a little bit more of the burden out of the courtrooms and move it so that individuals that failure to appear can kind of fill out a form if it's for a traffic violation and kind of handle that administratively, as opposed to having to go before a judge. The seventh recommendation there is encouraging district attorneys to utilize more amnesty and mass relief opportunities, things like such as dismissal of cases, forgiveness of court debt, and kind of mass expunction efforts. There are several district attorneys that are doing that throughout the state right now, and have utilizing data that the AOC has been able to put forth. And the recommendation is to encourage more district attorneys to do that, to address individual records that are a little bit older and that are holding people back from experiencing full citizenship. And the next set here, two-part recommendation, is broadly framed as putting an end to debtor's prison, and ultimately it is the stopping the issuance of arrest warrants for failure to appear charges without having a show cause hearing. That and then in addition to that, obviously precluding the imprisonment of non-payment of fees when an active sentence has already been imposed on the underlying offense. There's more detail on that in the working document. Our ninth recommendation is increasing access to licensed restoration clinics. My 10th recommendation is not including or excluding cases involving DWI offenses, stopping the suspending of driver's license for failure to comply for monetary reasons or failure to appear. We saw a lot of data on driver's license suspensions and how that is creating a lot of, and the majority of those being for things like failure to comply and failure to appear. And so just kind of wholesale stopping that practice, except for in cases of DWI. Recommendation 311 is to enact legislation that would automatically restore driver's license that were suspended for failure to appear after a 12-month period. I believe there's been legislation on the floor presenting that in the past. And then 3.312 is a recommendation regarding making the charge of driving while license revoked and decriminalizing that, pulling it out of criminal code and moving it to administrative court, and having it be an administrative hearing under the DMV, and that would be in cases, I believe, other than except for in cases involving DWI. And so we can pause here for any questions and discussion. That's a lot of information. Hopefully.
Does anyone have any thoughts or questions that they like to pose before we move to a vote?
Let me just say, these are kind of specific, but that's the nature of fines, especially in court. And I see it in district court. And people, I mean, for practical matter, people go to jail for not paying fines. That's why this issue is so important. Regarding the AOC form, the motion to waive certain fees, that was made available by the AOC in September. So that is available for defendants and judges and defense attorneys to use at this time.
Thank you, Judge Clark.
And if I could add that Judge Clark, and having been in district court, these may be minutia, but they are so important. We are criminalizing poverty, is affecting racial minorities more than anyone. But more than that, it takes up valuable time in a court shaking people's money loose from them. You know, if people want us to be serious about, you know, doing the work of justice and crimes and whatever, we shouldn't be just a money, you know, grabbing system for minor fines or offenses or failure to peers, and putting a $20 surcharge on someone who can't, you know, needs installment payments. It's gotten out of hand. And the General Assembly has really pressured every judge by having their scorecard, who's waiving costs and fines. And it's really been kind of intimidation, taking away judicial discretion. So I really applaud all these recommendations. They are very important. And I think it will dramatically improve our system of fairness and justice. Thanks.
This is Secretary Hooks, and I certainly agree with Judge Moray about we don't want to do things that criminalize poverty. I do have a question, maybe Judge Moray or Judge Clark, you know, as well. Would North Carolina be the leader in such things as moving things from the criminal district court over to administrative hearings, or have we seen successes in other states as a model?
Secretary Hooks, I don't have an answer to that question, but I did want to identify a potential conflict that I'm just noticing. There are two working group recommendations related to this issue. The one that we're talking about right now as a part of the fines and fees, and then working group 3 and its decriminalization recommendation, which is on hold for amendment, has a study on that issue. They chose to go with study the moving from the criminal code to the administrative code rather than actually to do it. So we probably shouldn't pass both. It's my gut feeling, but Representative Morey, you let me know what your thoughts are on that. And I know the Attorney General also had been doing some thinking about that issue.
Thank you, Jasmine. That's very helpful.
Any other comments or thoughts before we?
Secretary Hooks, I'm not sure that I have an explicit answer to your question about other states. But I recall 10, 15 years ago participating in a bar association review of decriminalizing some of these topics and switching them to the administrative setting. And we were clearly not the leader then. There were other states, and I don't remember which, that had gone down this road. And I imagine since Ferguson, there might have been other states that have come on board. I'll say one of the distasteful issues that came across 10 or 15 years ago was how much there was an investment in this lifestyle. The lawyers that made their living on it, judges that used it to, well, without characterizing people. I think it's an inefficient way of raising funds, but it's a very efficient way of keeping people under the thumb. preventing them from successfully reintegrating.
Right, and we run into difficulty with our reentry efforts where we're trying to reintegrate people into the community through reentry, but they've got so many of these financial issues or pending charges out here that it makes it difficult for us to get successful reentry when we return people to communities.
Yeah.
Okay, folks, we're at time.
I was just, Michael, excuse me, I was just gonna, to reconcile, so we're not actually doing conflicting recommendations today. What specifically was the study recommending work group 3, and which of these recommendations would it impact?
So the working group 3 recommendation says that in the part that says that we should collaborate with the General Statutes Commission to undertake an ongoing review, it says that this work should also study the implications of moving traffic offenses from the criminal to the administrative code. And here we are talking about recommendation 3.12 or 3.12, administrative license revocation, moving from criminal court to administrative hearings within the DMV, driving while license revoked.
I've actually heard that the DMV hearing fees are more costly to the person than the criminal fees. I've heard it's like $300 or $400. I don't know, Secretary Hooks, if you know the answer to that.
I don't know, but I suspect that you're correct.
I doubt, yeah.
One of the things that we had heard is that there might be some unintended consequences of moving to administrative hearings in terms of people's right to counsel and other concerns. And so that's how that ended up as a study as opposed to a concrete recommendation, because I think there are issues on both sides in terms of equity.
So I think what I would recommend to working group 4 is an amendment that strikes 3.12, since we are having it be studied, and another recommendation we're going to be considering later this morning.
I think that's a great amendment. And is that something that we can do now so that it's part of the vote?
Yeah, I mean, I think if we're just striking 3.12, we can just not vote on that one when it comes up. But I just wanted to get people's reactions to make sure everyone's comfortable with that.
I think that's the best plan.
Okay.
I don't like unintended consequences. So thank you, Jasmine, for flagging that for me. Thank you.
Very, very much. Thank you, Jasmine. Michael, I don't know if we're finished with the discussion or we can go on to the vote.
Yes, I think we can go into the vote.
Okay. Ellen, why don't you bring up the 3 proposals and we'll go through them all, and we'll just remember on 3.12 to just vote no for it, I think is the way, because if you leave it blank, you can't submit.
I removed it, so you won't have to have that conflict. So that's good.
No, Ellen.
The first one is on fines and fees. There will be 3 polls for this working group just by nature of the number of recommendations. So here's number 1.
You have to scroll down. You can't submit after the first 3.
I have a question while everyone's voting. Did we vote earlier on Working Group 3's recommendation was there an automatic strike of a failure to appear upon request by a defendant?
Yes, they can come to court in 20 days and ask for it to be, FTA be stricken and reset in court.
Okay, that's not very inconsistent, but a little different with our recommendation. And I'm not sure the number. Jasmine or Mercedes, you might need to help me, but we have, we recommended an administrative process for the first FTA strike. I just wanted to bring that to your attention before we vote on it.
We can work on, the staff can work on a way to merge those two and see if it's to the task force's approval.
All right, thank you.
Reconciliation. Brooke, thank you for bringing that to our attention, Judge.
All right, that poll has come to a conclusion. I'm going to share the results.
For those who can't see the results, it was the specific list of a whole series of different fee elimination or fee reductions, and they all passed, almost all unanimously. And the next poll. How are we doing, Ellen?
We are at 14:15. Very close.
Okay.
All right.
And the results, for those who can't see them, is all the recommendations in the second broad recommendation from this work group passed overwhelmingly or unanimously.
Just one more here.
The last one from this working group. Ellen, not everyone can see the poll.
Oh, they can't?
Oh, no, did.
Ellen, it was just there for a second for me and then it just disappeared. Is there a way that you can send it again to me specifically or?
I don't know.
Oh. Sorry, Ellen.
Oh, wait, it came back up.
Okay.
Woo.
I
don't have it all.
On this
one. I think if you hit polls at the bottom of your screen, it may pop back up. If you can see polls.
I don't have a polls.
Okay. Did it come to you, Chief Ledney, or did you get it, Chief Ledney?
I did not get it, no.
Well, I will send it to you. I will send the questions and then you can just email me back with your results. I can do that during the break. In that case, we have 16, so I'm going to end the polling, but I will get Chief Letney's responses over the break.
So my question is, was the fifth one talked about moving a DMV matter from the criminal to administrative. how does that fit in with the prior discussion we had?
I think we've decided that we're going to try to align those offline and
Okay,
probably.
that sounds good. Thank you, Mercedes. Okay, for those who can't see the results, they all passed fairly overwhelmingly. And Chief Ledney, we look for your addition to the results. All right, great work, Working Group 4. I think we are at a break, 11:55, perfect. Why don't we all take a 5-minute break and return to our computer screens at 12 noon on the dot.
Attorney General Stein, can I make just one comment before the break?
Please be brief.
Working Group 4 is having a meeting on Tuesday at 2 o'clock. It's different because we've got things that we think will be of interest to the entire task force. And so the 2 o'clock is a more convenient schedule. We invite as full of participation as possible.
Okay,
Thank you.
great. Thank you. Thank you. All right, see everybody at noon. Thank you. Okay, it's 12:01. If everybody can turn their screens back on, we'll know that you're here. Excellent. Okay, we will proceed to working group 1. Mayor Colvin, Leslie.
All right. Thank you, Mr. Attorney General. So I think that Ms. Ellen will pop everything up on the screen for me. So I think she could go back. Okay. All right. So first of all, I like to thank Ms. Leslie Dismukes and all of the staff for being very supportive, and the members of Working Group 1 have put in a lot of hours and time. We are a very diverse group. We're privileged to have 2 law enforcement professionals, Legislator and Representative Galliard, the 2 professionals, Chief Davis from Durham, as well as Sheriff Ingram from New Hanover County, and Representative Galliard. And so with that, as we talked about the civilian oversight boards, we discussed recommendations that have minimum standards and decertification for excessive force and abuse of power. We also, of course, know the problem of wandering officers who have an issue in one jurisdiction and are able to go to another. And Representative Gallup was very adamant in introducing psychological evaluation, mental health in some respect. Now, this part we had some pretty detailed conversation about, but I think the premise was to make sure that we are able to not only monitor the physical health, but the mental health of the officers, because that plays into the type of interactions that they have with the community. And so we did talk about that in those meetings. We have 2 additional meetings, potentially on the 11th, on the 13th and the 18th, and full task force meetings to kind of work through some of those pending issues. If we go to the next slide, please. Also, we talked extensively that any of the civilian oversight boards created should be established at the local level. Let me move my. Okay, so I can read. Okay, established at the local level in order to be responsive to local community needs. We certainly know the importance of that. Local COBs should also coordinate with NACO for best practices to make sure that policies and procedures are consistent with the things that they could support. Enact statute requiring that these boards register with on the state level and provide copies of their bylaws and policies, just to make sure there's consistency and there's legitimacy to the various boards, just so that we don't have various groups popping up wanting to take oversight over something as important as this. We wanted to make sure that they had some type of a requirement from a state level. And also looking to revise, make some statutory revisions that will actually allow registered state-approved boards to have some meaning. Right now, we know statute prevents the review of body cams, the review of personnel records. And so there was some discussion to allow some amendments to the statutes that are listed above to allow review boards as well as the local governing body to be able to take a look at some of these things. Right now, that's a challenge. We certainly need civilians, citizens, and our local elected officials to be able to instill confidence in their communities when an incident happens. And I think that right now they're precluded from doing that because of some of these statutory issues. And this would also, as far as data collection, well, are there any questions on the Citizens Review Board? I know this is kind of a topic that a lot of the working groups may have talked about.
And Mayor Colvin, if I just may, also in the slides to come, some of the questions that folks posed in the straw polls will be addressed also in those slides.
Okay. All right. As it relates to the data collection, I think is the next slide. Enact a statute that requires law enforcement to report to the State Bureau of Investigation a standard set of information with respect to the below types of interactions, and should include race and gender as a component, whether the involved subject is a juvenile or whether there are controlled substances involved. If we could turn to the next slide, please. And enact or recommend a statute to be enacted requiring the SBI to be designated to investigate officer-involved shootings regardless of whether it results in a death or not. Not sure if there's consistency across the state about the requirement for jurisdictions to do that and involve the SBI, but I think this would kind of make that a little bit more consistent. Also, all other OIUFI in which death results also involve incidents which death results for sexual assaults by law enforcement, officer involved custody and deaths, which we know that has happened in a lot of jurisdictions and could pose a problem with public confidence. And the SBI must request that any of these incidents be handled involving an SBI agent be handled by a neighboring out-of-state equivalent to the SBI. And so that just provides additional confidence in the oversight process. Next, okay. And also, we would like to recommend that that there be a statutory requirement for the appointment of a special prosecutor to handle these cases. Special prosecutor should either be a member of the Attorney General's office or staff pursuant to the statute, or from a neighboring prosecutorial district or attorney from the Conference of District Attorneys. And so we think that brought some sense of objectiveness to it. And as it relates to the no-knock warrants, certainly this was an issue that we discussed in detail with two professional law enforcement members on the work group. They gave a lot of different scenarios in which officers' safety could be put in jeopardy by some of the scenarios. Of course, we know that it's impossible for us to think of every possible scenario, but I think that these are the recommendations that came out in that respect. An officer may break or enter premises or vehicle when necessary, execute a warrant if probable cause is given of notice that would endanger the life or safety of any person, and such probable cause is specifically listed in the warrant. The legislature should clarify and define unreasonable delay as it appears in the statute listed. And also, I think that may have been the only one for no not. Next slide, please. Okay, all right. And
so I think this is where we get into the feedback, Mayor Colvin.
Okay. And so certainly would like to open up the floor for input and feedback and discussion concerning citizen review or oversight boards.
And just to jump in and give some overview, we did receive the feedback for the straw poll, and there were several concerns that were noted and wanted to address some of those. One of which was that civilian review boards or civilian oversight boards shouldn't have to register. In the discussions that our working group had, it was important to have some sort of process to ensure that the civilian oversight board who was receiving all of the personnel protected information was in fact a board or an entity that was legitimized by the local municipality. And so what we came up with was just having them register. Certainly that is not a barrier to a board being created. It's just a way in which that if these personnel files are going to be released to the Civilian Oversight Board, that we can ensure that we're not releasing protected personnel files to entities that are not supported by the community and by the municipality. So that's that was the idea behind the registration, is to make sure that they are blessed, so to speak, by the town or county that has stood up the board. The other concern was that there was some confusion regarding the distinction between the information used in the IA and then the documents that were in the personnel file. Essentially, we wanted civilian oversight boards to be able to have all of the documents and information from the investigation itself. So witness interviews and reports and that kind of thing, even if there were perhaps some documents that would remain in the personnel file and would remain protected at the law enforcement agency. So for example, our current personnel statutes allow for release of information like whether someone is terminated and the reason for termination. But short of that, discipline short of that is not necessarily something that's released. That doesn't mean that we didn't want the Civilian Oversight Board or the city or town or county council to be able to get that information. So that was the need for the distinction there. I'll pause for a minute if there was further discussion or question about those concerns. And if not, we can move on to the next topic.
And let me just, before Justice Earl weighs in, I think that this is a discussion that's taking place on the local government level. We're dealing with it here in Fayetteville, and the quicker we issue some type of state guidance or framework or recommendation, I think the better it will be from these local governments creating their version, although statute limits a lot of what it is. And this was important to distinguish that this is more of a procedural administrative review. There's a process for, criminals. So I think that there's some confusion with some of the local officials that what the powers of these boards may be able to do. So I just wanted to add that. But I'll go to you, Justice Earl.
Yes, thank you. I just wanted to, my own sense is that I just haven't seen that there's a problem with rogue civilian oversight boards popping up or trying to exist, and I just, it really kind of, it feels like you're taking control away from the local entity if a board has to register, and it just creates this state level involvement in what is supposed to be a local oversight process. So it seems to me that the change to the personnel law can say, that the files only be released to a review board sanctioned or passed by the local government. I mean, this seems to me a clearer and more concise way to get to your goal than creating a state registration approval process where there's no indication that there's been a need for it or some problem that would require creating that whole process.
Well, I think the thought process in that, and I certainly agree, you don't want to take any of that away from the local government. As a local government official, I certainly advocate for that. I think the problem is that you have so many jurisdictions and so many local governments that you may have so many different versions. So if there's a recommended way to put some framework behind it, because I think this is something because of the climate in the world today with law enforcement, I think you will start to see more of these formed. And I think, if I'm not mistaken, when we talked about it, there's a requirement for us, as well as some of the other municipalities, to get local bills to do it. And so I think if you can recommend a way, you, the members of the task force, can recommend a way that we can put some framework around it to make sure that it is a credible, legitimate, you maybe put the criteria in place in lieu of registration, that would be helpful. But I think that the state will have to set some guidelines, just because there may be so many different variations of it.
And I think Justice Earls, if I may, to your point, I don't think, based on the conversation during our working group, that the intent was to put additional burdens on the civilian oversight boards. I think the intent was, as you say, to just make sure that when we're releasing these records, they're being released to an entity that is in fact recognized by the town. And so the idea was to have a list of them where that is maintained somewhere, not that there should be certain criteria that they had to meet to register, simply that there was in fact a list of what boards existed and were somewhere with the state. So certainly we could accomplish that by changing the statute to include the language that you've proposed. I think it accomplishes the same goal.
So that would be my recommended amendment, that it say that the personnel laws, that the material be released to a board that's been established by a local government. And I don't mean to be clear, I'm not suggesting that there shouldn't be guidance at the state level about how the board should operate and what powers they might have, but guidance is very different from some standard that you have to meet to register.
Understood.
I support Justice Earle's amendment. I think as long as it's been approved by the local government, the city council, then that's all that's needed.
And that certainly was the intent of the working group, I believe. Jasmine or Ellen, do you want me to make that amendment for the end of everything after we get off this segment?
Yes, someone could give me the language. That would be awesome.
I'll get that while working group 2 is presenting. I'll get that to you.
Thank you.
All right. Ellen, if we can have the next slide, please. Going over here, some of the feedback regarding data collection. I think that there were concerns about the type of data and method of gathering. The conversation in our working group really centered around the SBI 122, which is currently the form that is used to report data for traffic stops. It's a PDF fillable, it's a checkbox form and designed to make it as easy as possible for officers. The idea was to combine all of the types of data recording on one form so that the legislature and in the new statute, someone would work with the SBI to basically have a form that replaces the 122 that allows us to gather data for all different types of things on one form, trying to balance making it as easy as possible in law enforcement to gather that data with getting the data that we need for types of interactions, community and police interactions that are additional to just the traffic stops. Again, the use of data collected about a single officer, someone noted that it was unclear. Essentially, the idea was that if agencies would like to get this data in a way that they could look at their individual officers and perhaps what their trends in enforcement are, that the officers should be able to do that, or that the agencies rather should be able to do that. And that would take into account, however, the area in which the officer works, which could, of course, affect the statistics for a particular officer. So it was wanting to make sure that data was available for agency use, not necessarily for any type of, it would be most appropriate for agency use. Then the difference between real penalties and failure to comply. The current statute that talks about recording the traffic stop data, I think it's 15A903, and that the SBI 122 is generated from. Essentially, if law enforcement agencies do not comply with that reporting, right now the statute only provides for a loss of their ability to receive state law enforcement grants. The working group felt that that needed more teeth and that there should be more penalties. We didn't take a stab at saying what those penalties are. We felt that was better for the next phase, but that we did feel that there should be real penalties for failure to comply with this data collection. Again, we sought stakeholder feedback from the SBI. Many of these recommendations deal with a burden for them. And so in response to their feedback, number 4, you'll note, is that's the only actual change to the language of the recommendation. And we've added a sentence to say that we will ensure that the enacting statute provides additional funding to the SBI for data, personnel, and for data storage, because this would be an increase over what they are currently having to collect and store and organize. And so we would want to make sure they have the personnel to do that. If there are any questions or concerns with any of these, and if not, I think we can move to the next one, Ellen.
Yes, this is Kerwin Pittman. So just looking at this data collection, I'm looking at the lack of transparency when it comes to it being searchable to individuals within the community or just non-law enforcement officers. This just one concern that popped out to mind, and for the oversight board that I didn't get to weigh in on. But the oversight board, the only concerning thing about the oversight board for me, even with complying with NACO, do we want to add some type of specification for individuals who are stakeholders within the community, spots on these boards? If we kind of leave it blank for local bodies, municipalities to come up with how these boards, and particularly who are implemented on this board, we might just be reinforcing the biases in that community. So we might need to lay out some specification about individuals or different types of stakeholders that needs to be at the table when these bodies are implemented.
And Mr. Pittman, I can tell you from the conversation that the working group had, as to your first point, the data, we looked at the California model, which essentially has a website that aggregates all of this data and allows for the general public to search the data by type of interaction, by race, gender, et cetera, substance abuse, anything like that would be available. The idea being, I think, that we would ultimately in North Carolina have something similar to California's website to allow us to look at the data from all of those interactions. So I think that was the spirit of the data collection recommendation. Certainly the development of a website, I think, comes next after we have a mechanism to collect the data. So we wanted to start with the mechanism to collect it. As to your point about the civilian oversight boards in our discussion, where we ended up, I think everyone felt that it was best to leave the development of the civilian oversight boards at the local level, because each community would need to develop their board specific to their needs, and then having some sort of state recommendation or overarching recommendation may be more onerous on these boards than the working group felt like we wanted to impose. So we started with a recommendation that any boards that are formed, we highly recommend they get in touch with NACOL and work with them to develop their board according to best practices. And we had a presenter from NACOL at our working group meeting to kind of walk through some of that for us. So hopefully that answers your question.
So the question I asked is then to that is, how do we ensure that the right stakeholders are at the table within these local municipalities? Because they could just put anybody at the table who are not real stakeholders within the issues. And I feel like those who are closest to the pain should be closest to the power, in a sense, when it comes to that regard, or their voice should be heard at that table. So how do we ensure that?
So let me make sure I'm understanding. When you're saying local stakeholders, are you saying people who I understand who may have some involvement or expertise in that subject? Or are you saying to make sure that all aspects of the community are represented fairly in the creation of the board, like, you know, a victim's family or something like that? And I guess part of the answer would be, being that the local officials are elected in that community, I think that they're accountable for anything, just like any other action that they create. Like, how do we know that some of the other policies they pass are equitable or whatever, I guess is your question. And I understand that. I'm just a little hesitant to see how we could probably put anything in there from a state level that required you to include certain things when every community is different. You know what I mean? It's like, without saying race or gender or you know, a victim's family or a member of a bar or something like that. I mean, I don't know. I understand the concern and I feel it. I'm just trying to see how we could do that in a way, because each community is different, and only the governing body, the actual people in that community, sent them there to make those type of decisions. But certainly open to any guidance on that.
Mayor Colvin?
Yes,
for
ma'am.
me, I think it should be that those who within the community who are actively involved already in reform and equity, like for you, that would be a member of PAC, possibly being on your council, on your review board, or I don't know about other places, but to me, that's what that represents to me. It would be strange if they were not invited to the table, since they talked about reform and accountability in your area.
Oh yeah, no, I think in our particular case, definitely representatives like PAC. I was just saying, do you have a PAC in every community, being that they're not a statewide? So I understood that part, but definitely that weighs into the decision that we'll make to make sure that you have people who represent both sides of the issue. Sure.
I guess my concern is just that the right stakeholders at the table, regardless of what community they're in, because we know and understand that there's racial inequities all over the state of North Carolina, and though each community may be different, I still want to kind of ensure that these individuals' voices are heard, specifically those who are most marginalized and those who are most oppressed and those who advocate for these individuals. And that's kind of my concern.
So Kerwin, if I could, I think one of the things that Leslie was getting at is that those NACOL best practices have that similar sentiment in them. And so it's not explicitly said in the recommendation right now. So what I'm hearing from you is that you might be proposing an amendment that we have at least one explicit sentence about the importance of community stakeholders being involved, but not having specifics about that, and just would want to pull that concept out to be explicitly stated.
Yes, that would be perfect.
Let's see, about 5 more minutes.
Okay, I think, Ellen, if we could have the next slide, I think we still have 2 more subject matter areas to cover. Okay, investigation and prosecution of officer-involved use of force incidents. Some of the feedback here, I will take the 2 and 3 first because I think they are more straightforward. One recommendation was to add acts of domestic violence by officers to the definition of officer-involved use of force incidents. That language has been specifically added to the recommendation now pursuant to that feedback, which I think was not, we did not mean to overlook that in the beginning. So I certainly think that is good feedback to add there. And then stakeholder feedback from the SBI wanted to make clear that the SBI should only be responsible for criminal investigations and not investigations involving violations of policy, which of course would not be within their statutory mandate and their jurisdiction. And then also that the statute must establish a process for conferring jurisdiction upon an out-of-state SBI counterpart like SLED to investigate SBI officer-involved use of force incidents. That's a little bit unprecedented, but right now, if we were to call SLED in to investigate an officer-involved shooting of an SBI agent, involving an SBI agent, there would be no jurisdiction on the part of that external agency. And so we would need to specifically confer that jurisdiction on an external agency in order to conduct that. We obviously don't expect that this will happen, but it's a contingency process in case that it does happen. So those 3 things in 2 and 3 have been explicitly added to the recommendation since you last saw it in response to feedback. The other concern that was noted, if we can go back one more, Ellen, the other concern that was noted was a lack of community trust in the SBI performing these officer-involved use of force incident investigations. And I think that it's important to note, based on our discussions, that there does have to be an investigation before any concerns can be addressed, and there has to be a body to investigate. And while the SBI, I think for North Carolina, is probably the best suited law enforcement agency for those investigations, it's important that the SBI need to be transparent about those investigations and also take action to build a community trust in those investigations. So that's some of the discussion that we had in the working group surrounding that issue. If there are any questions, concerns, discussion about that. And if not, the next slide I think is, I'm sorry.
Thank you, Leslie. This is Secretary Hooks.
Yes, sir.
Can you offer any more light on a concern about the lack of community trust? I think just like Angelica Wynn announced earlier, that there are different aspects of communities for victims. I don't really see that there's this broad lack of trust in the community. The Black community is not a monolithic community when it comes to SBI. And I'm not trying to be defensive about it to any degree. I used to supervise all of the officer-involved shootings in North Carolina in the late 90s and early 2000s. And I know that SBI is situated and postured to do that, and it's taken a number of years, but even Charlotte has now includes them into making requests for the investigation. So as I not just work through the recommendations, but look to seek to bridge gaps in communities, is there something readily apparent that could be stated that I could move them toward about building greater trust? Just real quick, but I don't want to slow us down in the meeting today.
Yes, Mr. Secretary, and I may defer to if there is a person who made that comment that might want to speak to that more broadly. I think that what we have been hearing anecdotally is that there is just simply a lack of trust in those types of investigations, and giving it to the SBI as opposed to another agency may not solve that problem. There wasn't a specific point of feedback, I think, that would be a takeaway for you or for the Department of Public Safety. But I will say that we did consult with the general counsel from SBI and had a meeting with them before taking this information to the working group. And of course, they were able to answer a lot of our questions about how individuals are assigned to these incident investigations, and that there are strict policies and training specific to these types of investigations. And I think a lot of that information, if it were more widely known to the community, might build trust in the process that the SBI is already currently undertaking. So that may be one point of feedback based on that information.
And just a quick response, Secretary. I mean, it was something we heard in our public forums. We heard that a few times where folks said that they were dissatisfied with the SBI investigation, but I didn't hear any alternative proposal. Like, folks don't want the local law enforcement to investigate themselves. So I'm sort of where Leslie is, that it's just a matter of making sure that the public has a better appreciation for the professionalism with which SBI conducts these investigations. I just don't really know that there's any alternative.
Thank you, sir, because I didn't know if that was results-based because there weren't more officers charged or there was some specific component to how they were conducted. So thank you. I don't want to use the work group's time, but I did.
I know we're pressed for time, but I quickly want to say thank you for asking that question. I actually think that this is the kind of thing that a future commission can assist with. That is to help with transparency, help with monitoring, to say to the public, no, actually, look, the SBI can be a trusted independent agency. But I will just say from my experience, this is a little bit dated now, but from litigating cases, there was in the past an experience of the SBI never ever finding any violation, and so that I think that created the perception. I think that is no longer true, and so to some degree it's a perception issue. But I do think it's an important one, and that it's the kind of thing that we can actually assist with.
Thank you, Justice.
And I think, Ellen, if we could have that slide back, there was a question about the investigation by the district attorneys. This recommendation also, as Mayor Colvin stated, would mandate that it had to be an out-of-county prosecutor. And I'm not sure if we could get as specific as to say that it had to be an unrelated prosecutor. I do know that that was the note in the chat. I'm not sure if anyone wants to speak further to that point. That's not something we thought about in the working group.
I didn't think about it till I saw it, but I live where there are twin brothers who one would go replace the other if it was to be the next district over. So tell me they would not be supportive of each other is another thing, because it was nepotism when one hired the other to ascend to where they are at this time. But I was not in the position I was in at that time.
I can speak to that. I'm certain that they wouldn't do that because of the perception. And in fact, there was an officer-involved use of force incident in, I think it was John David's district, and he referred it to our office and not to his brother's office. So I don't think we need to, I think the fact that it can be referred either to the DOJ or the neighboring, I think covers it. I don't think it would happen.
Thank you, Attorney General.
Thank you.
And I will keep them accountable, don't worry.
I have no doubt, and I'm glad you will.
Ellen, if we could have the last slide. The last slide was a change to the no-knock warrant statute. The only actual language that we added to the statute, you will see, is right now, the second part of the statute says that there has to be probable cause to believe that it's necessary to protect life, essentially. But we made it a requirement that we want to request legislation to make it a requirement that that probable cause has to actually be presented to the judge as a part of the search warrant and signed off in the search warrant. It's our understanding anecdotally that that is happening right now anyway, that most law enforcement who anticipate that they will need a no-knock already write that into their search warrants. But this would make it mandatory that they do so and have a judge decide that there is in fact probable cause there existing. There was a concern about the definition of unreasonable delay and the fact that it needs to be decided on a case-by-case basis. I don't think the working group's thought that we should have the legislature clarify the definition of unreasonable delay was meant to take away that case-by-case decision. I think the case law probably bears out that it is in fact a situation-by-situation analysis, even if we were to have more clarity in the statute. And that's all I have, unless anyone has any questions.
Thank you, Leslie. This is Eric Hooks again, and I don't want to dominate the discussion. I appreciate that that viewpoint and that clarification on unreasonable delay, because I think it's so hard to define legislatively that we would never get to there without it having some grave unintended consequences. One of the other things concerning that would encourage me to further support the recommendation, certainly support the recommendation that the SBI conduct the independent criminal investigations to all agencies, and whether or not that's codified or not, either way, that's the way it should be. But the addition that to have out-of-state law enforcement agencies such as SLED come in, SLED's not empowered to conduct criminal investigations in North Carolina, and so that it just doesn't ring feasible to me. The FBI certainly could investigate shootings or incidents that as well as the U.S. Attorney's Office and the VA can certainly activate their authorities to call in other independent resources to conduct criminal investigations. And then as much respect as I may have for SLED or Virginia State Police, I don't offer them as any more qualified or in tune with our communities or professional than any law enforcement agency in North Carolina.
I don't really like bringing in an out-of-state group either. I mean, I think there should be some independent investigation of any SBI event, whether it's done by Charlotte PD or Raleigh PD or the FBI. But I don't know that we need to be bringing in out-of-state folks to do that. And I wonder if we can just be a little more generic and say that any SBI event needs to be investigated by another organization other than the SBI, and kind of leave it at that.
General Stein?
Yes.
There is a protocol being developed by several of our neighboring states on this very topic. It's coming through an association of state criminal investigative agencies that was being chaired by the Georgia Bureau of Investigation, started about 1.5 years, 2 years ago. And they were grappling with the same topic and what is a best practice. What they are trying to come up with, and I'm not sure where they are now, I haven't touched base with this group in some time, but they were trying to develop a standard protocol for state investigative agencies to do officer-involved shooting investigations across this region of the nation and beyond if possible, but then also deal with what happens when it is a state agent. And they did have some reciprocity agreements they were talking about, as well as a standard protocol that would be followed from North Carolina to Georgia to Tennessee to Virginia and so on. So there is some significant work being done on this, and I would recommend maybe we look into that and see where they are, and if that provides any closure to the conversation or any advice for a recommendation.
Well, then I think if we just take it one step higher and just say SBI to be investigated by some independent organization, we don't have to resolve this issue, whether it's an in-state or out-of-state or federal or state or local. Just for us, I think the key point at this stage is the independence of that investigation, and we can let the legislature figure out the right entity.
Will that be an amendment?
That's an amendment I suggest. Does that work for the working group folks?
Sure. Yes, sir.
Great.
Not other comments, then, oh, Mary?
I have a question about the no-knock warrant recommendation, and I support the recommended solution. When I was reading through the recommendations, the problem statement, and the value-oriented future state, I had some questions, and I wondered, is this language going to be part of the final task force report? Because here's my concern on this one. says anecdotal evidence gathered from statewide law enforcement officers demonstrates that no-knock search warrants are rarely used in North Carolina. That's from the problem statement. And then the value-oriented future state says North Carolina will pursue a campaign to educate the public on how infrequently no-knock search warrants are actually used. And I guess I just have a little bit of hesitation about recommending a policy or based on anecdotal evidence, at least without more explanation of what that evidence is and how it was gathered. I don't doubt the underlying statement here. I worry about putting that out there as a task force recommendation. And that's my comment. So.
I think we can address that in the editing stage, but makes sense.
So I should volunteer to be an editor, maybe is.
Welcome to the team.
Okay.
Well, actually, I did want to make clear, everyone will have a chance to give us feedback and edit the entire report. So you don't have to be on the editing team, but it would certainly help us if people have time to do that.
All right, Attorney General Stein, I think we can go towards voting now.
Okay, great. A couple of them I know are being pulled out for amendments, but those for which we are ready to vote, Ellen, if you could bring forward.
Yes, I think we now have 4 that remain from this group, and I will launch it now.
Great.
We are at 15 votes, so I'm just giving folks just a few extra minutes.
And we did lose Henderson for the afternoon.
Oh, okay, then we are at 16, so I will end the polling. Thank you. And share the results.
And for those watching on the internet, they all passed overwhelmingly or unanimously, and these had to do with data collection, among other things. So Ellen, I can't remember. Do we have more polls at this point?
We do not. No, we can move on to working group number 2's presentation.
All right, great. We'll bring the other recommendations as amended at the end, and we'll go on to working group 2, whom Secretary Hooks, I know you will go as expeditiously as possible, as always.
Yes, sir. Appreciate it. Thank you. And Justice Earls for your leadership. I do want to thank all of our work group members for the outstanding work that they have been doing. They have been immensely in tune to everything that we've done. I would individually call you out, but I do want to make great use of our time as I'm balancing a number of things, and our substantive staff lead, Jeff Welty, is too. And so we have taken on a variety of things. Use of force, a number of recommendations have already come before you, and that work continues to be ongoing. So I won't rehash those. Some of the other things that deal with the progress of our and future meetings. We had an outstanding meeting on traffic stop data, the reporting of that, and added perspectives of how to apply traffic stop data to promote substantive changes and promote racial equities in communities, particularly where it surrounds traffic enforcement that deals mostly with issues of regulatory issues such as expired plates and those things. That again, criminalizing poverty and unnecessarily increasing public police contact in an adversarial way. And so those are some of the things that we have addressed and have a way forward. And I'm going to quickly just turn it over to Jeff, and he is going through, going to present some of the other initiatives that we have for the group today so that we can make great use of your time.
Okay, thank you, Secretary Hooks. As the Secretary mentioned, we presented a number of recommendations last time, and we've got some more this time. They are generally around two topics. The first one is community policing, which is kind of the dominant modern philosophy of policing. And just to summarize generally where we're at with that, the working group heard from several experts, both inside and outside law enforcement. And the message that the group got is that while community policing is widely accepted, sometimes agencies' commitment to it isn't as deep as it could be. And so the group came up with 6 recommendations for the task force to consider. Each of the 6 recommendations passed unanimously or nearly so out of the working group, and in the straw poll process, each one passed with no more than 1 dissenting vote in the straw poll from the entire task force. So there's strong consensus, I think, around each one of these, and the first couple of them are on the screen. The first one just encourages agencies to adopt community policing as an agency-wide philosophy and co-produce public safety in close collaboration with the community. That's really a sort of a statement of the community policing philosophy itself. The second one gets a little bit more concrete and encourages agencies to develop community policing plans in collaboration with the communities they serve. Again, the idea being to take that commitment to a deeper level to further embolden or strengthen the collaboration between agencies and the community. If we could go to the next slide. The third one recommends that the Justice Academy develop training for agency heads that focuses on community policing and make that widely available throughout the state. The Justice Academy already has a certificate program in community policing, but it's not focused specifically on agency heads. And one of the things that the working group heard was that the agency heads' commitment to community policing was obviously a driving force behind the agency's overall embrace of that strategy. The fourth recommendation would be to encourage or require officers to spend non-enforcement time in the neighborhoods that they serve, doing community service projects, talking to residents, coaching sports teams. And we noted, and some of the officers within the working group recognized that that would require some changes to officer scheduling to allow that time to be sort of counted as work time, and there's potentially a resource implication there. But the group heard a number of examples of the values of that kind of activity from our speakers, and so again passed that out of the working group. If we could go to the last, these are the last 2 for community policing. The fifth one, which passed unanimously out of the group and also at the straw poll level, was to encourage agencies and local governments to consider providing financial incentives like housing subsidies to encourage officers to live in the communities that they serve. Folks may know that a lot of municipal police in particular, given their salaries, don't live in the cities where they work. And the sense of the working group was that divides them further from the community, makes them feel like outsiders, and diminishes the level of familiarity that they might be able to have with the community. And then the last recommendation is simply that agencies publicly acknowledge mistakes that impact the community as a way of building trust and transparency with the community. So those are the 6 recommendations on community policing. I'll pause here in case there's discussion about any of those. Again, I think they were all unanimous or nearly so at the straw poll process, but that doesn't mean obviously that folks may not have comments, suggestions, or amendments at this point. If there aren't any, then I think we could turn to our Reinventing Public Safety recommendations. And there are 2 of these. The first one is on the screen, and it relates to what are the term of art is violence prevention programs, or sometimes violence intervention programs. And this recommendation is for grant funding and technical assistance to support communities in developing such programs. One model that people may have heard of is the Cure Violence model. That's a community-based violence intervention program that uses members of the community to mediate disputes and attempt to stop violence before it starts. There are also hospital-based violence intervention programs, and one of the speakers that we heard from, Dr. Kyle Fisher with the Health Alliance for Violence Intervention, spoke about the benefits of hospital-based violence intervention, where people who are actually hospitalized as victims of violence are at a moment where they can be reached oftentimes, and addressing them about what they've experienced and how to prevent cycles of retaliation from getting started can be very valuable. So this recommendation simply encourages communities to look at those kinds of programs and encourages grant funding and technical assistance through a variety of means to be made available to support that. If we could turn to the last one. The final recommendation that we had was for communities to form community safety and wellness task forces that would essentially be community groups that examine public safety and wellness needs in those communities and evaluate existing resources and make recommendations for additional programs that may be needed. We heard from Jillian Johnson, who's the mayor pro tem of Durham, who spoke in a very convincing way about the community safety and wellness task force that they are building in Durham. It's a collaboration between the city and the county, and there's a number of other entities involved, but it will function sort of as a hub for non-law enforcement community safety resources. It will identify needs, it will direct resources, it will evaluate programs to ensure that they're working. It seemed very well conceptualized to the group, and other communities following similar type models had very strong support within our group, and I believe passed unanimously in the straw poll process. So I'll pause there to see if there's any questions or discussion or amendments to either of these two reimagining public safety recommendations. If there is nothing from anyone, I guess that's the benefit of going last. People have sort of spent their energy on other issues, but I'll turn it back to the Attorney General if we're ready for voting.
Jeff, you should interpret it as your work was so well reasoned and articulated that there's no questions behind them. So
I'd like to think of it that way. Thank you.
All right. I guess in that case, we'll go ahead and vote on each of these. Ellen, if you can bring them up. Well, let me just make sure. No one had any questions or amendments? Okay, very good. Ellen, if you can bring those up, the polls, that'd be great. So we were able to fit all of those on one poll. Is that right, Ellen?
Sorry, I've been muted. That is correct. Yes.
Okay, great.
Well, sir, that is the balance of what we have to offer for work group 2. I need not tell you, I know you know that Jeff and Greg and Ellen and everybody has just been tremendous for us and outstanding, and the work group has been really intentional and engaged, and at times we've certainly practiced what I believe that iron sharpens iron, and we challenge assumptions and challenge each other in a very professional way, and I think we're all the better for it, for our pathway forward.
Great work, Secretary Hooks. Thank you.
We're at 16 votes, so I think I'm waiting on one more.
Remember, Henderson's not here.
Yeah. Perfect. All right. Ending polling.
And the results for those unable to see them at home are all of them adopted unanimously. So very good work. Thank you very much, Working Group 2. And now we had a series of recommendations we discussed earlier with amendments, and Ellen and Jasmine, tell us how we want to proceed to do that.
I'm going to pull up, share my screen and show the red line edits that we made, and then Ellen will pull up the revised polls. So the first one was Sentinel event reviews.
And this had to do with the issue that Henderson raised about the AG selecting these positions and consulting recommendations from the legal folks. And so we added the language at the bottom about the legal organizations producing some recommendations on the legal profession, but the AG would make that choice. Anybody have any questions or concern? I wish Henderson were here. He can weigh in after the fact if it didn't accurately reflect what he had said, but I think it does. All right, if no questions, then why don't, Ellen, you bring up the poll?
Great. Sorry.
And just to be clear, by voting yes, Jasmine, it's not only on the amendment, but it's on the underlying recommendation.
That's correct.
Right. If you preferred it as original, vote no on the amendment, and then we'll bring back the original. But if you're satisfied with the amendment, we'll go with it as that.
All right, and that and share the results.
Okay, as amended, approved unanimously. Thanks so much. Next.
The next one is decriminalization. And we deleted public urination here. And that was the only change, but I did want to also call the task force's attention to this language here that we talked about in terms of the conflict with working group 4s. This work should also study the implications of moving traffic offenses from the criminal to the administrative code.
Okay, that's helpful. And this addresses the mayor's point that we want to make sure that we are not predetermining the public health consequences. We'll let the scientists tell us that. Anyone have any questions on that before we vote? All right, Ellen.
Yep.
So there are numbers 3 and 4 on this amendment. Ellen, if you can, what does the appointment of counsel and IDS have to do with this?
I had pulled all of the set of decriminalization recommendations when we were going through it the first time. So these did not get voted on. So they're just included here since I had pulled all of them during the amendment process.
Okay, great. Well, then explain to us what the amendments were that we're voting on. So I know exactly what we're doing.
So there's just one amendment. It's just the public urination. So that's question 1. And then all of the others were the original recommendations that working group 3 presented. And I'm not sure that we got into a lot of detail or discussion about them. So Representative Maury, I'll defer to you if you want to explain anything about those last 3 questions that are on the table.
Yeah, sure. Just briefly. And we missed that one slide when we went through it. Basically now, if you're charged with a class 3 misdemeanor, you are not allowed to have a court-appointed counsel. depending on how other recommendations go, if class 3 misdemeanors remain criminal charges, if a person's facing a $200 fine, as well as an arrest for failure to appear or failure to comply, that they are entitled to have the assistance of counsel. And if they apply for a court appointed, that we also need to increase the funding for the indigent defense services to provide counsel in all these additional cases. Up until a few years ago, everyone was afforded the right to counsel, and then the General Assembly changed it. Any class 3 misdemeanors would not have that right. So it's giving back the right to counsel for anyone charged.
Anyone have any questions or concerns about that? Okay, great. Well, with that information, let's all cast our votes on this series of amendments.
All right. Let me share the results.
And these amendments all passed overwhelmingly or unanimously, which is also overwhelmingly. Any others?
Yes, there are a few more from working group 1.
Okay.
Can you see my screen?
Yes.
Okay, the first one was related to Kerwin's recommendation. Number 2 here, having an explicit sentence about who should be engaged in the membership of a civilian oversight board.
Okay. Was that the only change here, or was there additional?
No, yeah, there are a couple of more. The second one is related to Justice Earle's amendment regarding how civilian oversight board should be identified as sanctioned. And that's their 2 places here. And then scrolling down, this is a separate recommendation. Ellen, I don't know if you've done this in one question or 2, but I'll also identify that the edit to the SBI will be, investigation will be handled by an independent entity, taking out what that entity would be. And then I also wanted to highlight, this is not a change, but given the discussion regarding the SBI and community trust in the SBI, that this language is in the value-oriented future state, this highlighted language here, for further wordsmithing if folks would like, but that concept of sort of how to increase community safety was contemplated.
That's very helpful, Jasmine. Thanks for highlighting it. Okay, all of those amendments give effect to our prior discussions. Anybody have any questions about those before we vote? Okay, great. Ellen, you're up.
So this poll includes both civilian review boards, the changes to that, and the change to the SBI investigations.
Very good.
All right.
And those passed overwhelmingly. Thank you. All right, so is that it for the amendments?
Yes.
Okay, great. Thank you, Ellen and Jasmine, and for doing all that work on the fly. It's not only the substantive work, but then getting us the polls for us to respond to. Very, very impressive. And thank you all, Task Force. Henderson's not here, but now he understands why it's fun, because we're actually producing the work after many hours of deliberation. And that really is a reward in and of itself. And so I'm very appreciative of everybody's hard work. We've got a couple more weeks of bearing down to do, and let's do it. And we're going to come up with a product I think we can all be proud of. Justice Earles, any final words from you?
No, that's it. Thank you all very much.
Okay. Have a wonderful Friday and weekend, everyone.